Thank you, Joel. Thank you, Balint, for the invitation to the conference. I'm not a philosopher, I'm not a political scientist, I'm just a boring lawyer, so I'm going to concentrate on the law, but I will try not to overdose the legal details, but I'll also try to follow and concentrate exactly on the role of the law in this transition exercise. So I would start first with major lessons learned after the rule of law crisis in Poland, again, from the legal perspective. I think the major lesson is that the constitutional crisis showed that there is also a crisis of sanctions in the public law. One of the reasons is because of the violations of the public law. So, the way the courts were appointed or the judges were appointed were to some extent normalized. There were some also overdose in this sense, which resulted in a situation when the enforcement of the constitutional law became also almost impossible. Not in a kind of criminal sense that someone will face criminal liability because of that, but also other branches of law like civil law, criminal courts law, they don't know how to react to the situation that the public law was violated. It's a completely different situation compared, for instance, with the civil law. So this is a major shortcoming of this element, but I think this also has an impact on the transition, how we could see what should be considered as the aim of this transition to the rule of law. On a very micro level, you could think about ensuring accountability of those who violated the law. So you can think in a very traditional way, criminal liability of those who violated or abused the law should face liability. And here, when we discuss potential exceptions in this context, whether it's possible to violate some law in order to rebuild the law, in this micro level, so ensuring criminal liability, there's no room for exceptions. We can discuss later whether there's a room to violate the law in institutional context, but in this criminal level, it's almost impossible in order to ensure the aim, such as rebuilding trust to institutions. We can also think about the macro level, so trying to rebuild those big values and big constitutional norms, such as separations of powers or ensuring judicial independence. This could be another level of thinking about transition. Then we can also think in a more kind of technical level that lawyers will love to discuss, how to implement the judgments of the European Court of Human Rights, European Court of Justice. This is the easiest part because you know what is the aim. This is a self-legitimate source of action. You have to implement the judgments, and this is kind of easy. But there is also another level which is usually dismissed in this discussion. It's more kind of substantive dimension of this transition. When you think about the laws that were introduced, which do not deal with the institutions, but deal with human rights, such as abortion law, which is amended indirectly by the tribunal in 2020. And somehow, despite we are discussing at the moment all possible issues dealing with judges, institutions, it was clearly said by the Prime Minister that the discussion about abortion is going to be postponed to other times. So you can see the scope of potential aims of transition is quite broad, but at the same time, from the legal perspective, the way how it's being done, what are the methods, is absolutely crucial. Another lesson learned or kind of outcome of this crisis is the fact that there is no arbiter in this discussion. Because usually this role could be played by the highest court, Supreme Court, the Constitutional Court. Here we don't have such an arbiter. There is no one domestically who is going to review the decisions or new law adopted by the Parliament. You could look for this kind of arbiter outside European Court of Human Rights or Luxembourg Court, but at the same time, because those so-called autocratic enclaves are still there in the system, you can easily face the situation when the outside decision, when the outside verification will be denied by those resulting from the backsliding from the autocratic regimes. And now I want to move to the role of the law in this transition process. And I would start with the fact that the legal norms are basically the subject of the transition. So some of the laws, they need to be amended. And you can see, again, easily you can find a source of inspiration from the from Strasbourg Court, what law should be amended. Again, this is quite easy. But on the other hand, the law is also a method to achieve this type of aim. So you need to amend the legislation, which is quite difficult when you already know you're going to face institutional limitations such as presidential vetoes or potential obstacles from the captured constitutional tribunal. But at the same time, legal procedures such as criminal trials are going to be also considered as a method here in this process. Furthermore, the law is a factor of stabilization in this whole system. As you can see, the transition usually involves some sort of risk. And here it's difficult to compare it with 1989 transition, but still digging with the highest constitutional norms and institutions can be a source of some sort of chaos, especially if one of the methods that you're going to use is to actually violate a binding law with good or bad reasons. The fourth element, which I think was already discussed by the two philosophers today, is that the fact that the law is also a source of limitation. The very essence of the rule of law is to limit the public power. And here we're facing a situation when mostly the executive is going to decide which law might be violated because they were illegitimate from the perspective of the whole constitutional arrangement. John Moran said that this restating of the rule of law is actually an art of self-restraint. And that brings me to the fifth point dealing with the nature of the law, is the fact that the law underwent really important transformation in the recent backsliding time. On the one hand, the role of the law was undermined because it was used as a smokescreen in all those legal and political debates. For instance, my PhD supervisor, Professor Wyrzykowski, argues the Constitution is actually dead. You don't have the arbiter, you don't have the tribunal, it's actually empty. But on the other hand, the very fundamentals of the rule of law, such as judicial independence, it was actually strengthened by the outside players, actors, by the European Court of Human Rights, by the European Court of Justice. However, in order to implement those outside suggestions or judgments, implementing those rulings might require overcoming this kind of traditional legalistic thinking about the law, which might be also a source of problems for the lawyers. Here is time for example. I will try to make it as simple as possible. In September, there was a ruling in Luxembourg about this extraordinary chamber of the Supreme Court. The Luxembourg Court already ruled on a couple of times that the judges appointed to this extraordinary chamber, they cannot be considered as a court. This is the whole chamber. And here in September, the court ruled that because they cannot be considered as a court, their decisions cannot be considered as judgments. So all those decisions should be considered as null and void for the purpose of the primacy of the EU law. On the one thing, it could be considered as an easy thing to implement. Just another court who's going to, have a case dealing with the extraordinary chamber decision, they should find such a decision null and void. But when you think about legal stability and the fact that someone already, changed their life because of the basis of the final judgment, the cost of such judgment could be extremely high. I think at this moment it could be also asked, what is the role of the EU as a whole institution? What could be the role of the EU in this kind of transition process? And it turns out the EU decided to get rid of all possibilities they had. So they decided to close Article 7 procedure, which is still pending in case of Hungary, so good luck. In case of Poland, they decided to close this thing, and they lost the platform when these decisions, when this transition could be actually discussed at the EU level with other peers, with other member states. The Recovery and Resilience Fund, it was also released to Poland, so the new executive, the new government could show we are super effective in rebuilding rule of law standards, whereas nothing has changed as a result of the funds being released. And that brings me to a final question. what could be considered as a sign of success in this transition? In my opinion, those are three things. The first one is stability of those changes. As Tom Daly said in his paper about this constitutional repair, we should avoid the situation when the same methods could be used or abused by the next government in case autocrats are back in power. Ginsburg and Hook, so those who actually came up with this democratic front sliding concept, they said that the good functioning of the elections is a priority. And this is something which was also discussed in Poland in case of deciding whether the presidential elections in Poland were actually legitimate and lawful. It was also part of the discussion. It was decided that despite the fact that this extraordinary chamber, unlawful in the light of the EU law, they had the possibility, they had the power to decide whether the elections were actually lawful. The second factor in this success exercise is it depends on the communication, whether people, the changes need to be understandable in order to be stable. And it's a great task for mostly the executive to explain why we are actually introducing such major changes to the constitutional order. And the third element, which I think needs to be crucial here, is proportionality of those changes, and that also requires as much legality as possible. And that brings me to a paper of Hilion, Pavone, and Sheretz, who deal with this restorative disobedience, which they are trying to implement this idea of proportionality, how to allow for disobedience, meaning disapplication of a binding law, but at the same, how to limit the potential harms here. So they said, any restorative disobedience has to be very well tailored. It has to be very well justified. So you have to communicate to people why you're actually violating the law. And they also said that the EU institutions should be engaged. As I mentioned before, it will be super difficult without proper procedures. What is, however, missing, I think, in this paper is judicial review. So the fact that the government, the public powers are going explain why they don't follow the law is not enough to make it stable and to make it a legitimate situation. And I can give you another example here, a dismissal of the court's management, which was done by the new Minister of Justice, Waldemar Żurek. He did it despite the fact that the procedural requirements were not met in practice. He said he's not going to apply for the opinion of the National Council of Judiciary, of the capture institution, because it's captured according to the EU law, according to the Strasbourg law. At the same time, there was no judicial review over his decision, so the standards from another Strasbourg decision, Broda Bojara versus Poland, they were actually not met. So the question, what's going to happen if those decisions are going to be found as illegitimate or unlawful at some point, maybe by Strasbourg. Another requirement, which I'm going to just mention briefly, is that this process has to be as inclusive as possible, which might be quite a challenge, especially domestically, when you have to make, for instance, judges appointed after 2018 to be part of this transition process. But also it should be inclusive internationally. So the Venice Commission, like an expert body, should be also engaged in this process. Interestingly, the Minister of Justice withdrew the invitation for the Venice Commission, but they still arrived. So today they're discussing in Warsaw, they're discussing the new law on judges. Since I have around 30 seconds left, I just want to say that despite I really enjoyed the discussion about moral dilemmas, I think the transition is not about moral issues. It's rather exercise in pragmatism. And it might be that the process might be very time-consuming and it will be painful, but it cannot kill the patient. And I think this should be the major aim in this procedure. Thank you.